esta nueva masterclass en la que hoy contamos con Michael Sukin, que ha venido desde Nueva York, y al que agradecemos muchísimo su esfuerzo por estar aquí en Madrid. Después de un largo viaje por toda Europa, ha tenido la diferencia de dar un salto hasta aquí para estar esta noche con nosotros. Hablar de Michael Sukin es hablar de la industria de la música en Estados Unidos, lo ha sido prácticamente todo. Es abogado, obviamente, como sabéis, fundador del despacho Sukin Law Group, pero además es muchas otras cosas, fundador de la Asociación Internacional de Abogados del Entretenimiento, y ha sido un asesor para la Comisión Europea en temas relacionados con propiedad intelectual, y en particular tuvo una actividad muy intensa con motivo de la Directiva de 2011, en la que se amplió el plazo de protección de los derechos de propiedad intelectual de artistas y productores. Entre los clientes del despacho de Michael figuran autores tan destacados como Elvis Presley, como los Rolling Stones, como los Clash, como los herederos de George Gershwin, y bueno, ha ejercido su labor como abogado y lo sigue haciendo tanto en Estados Unidos como en Europa, en Japón, en América Latina, y como os digo, es una leyenda viva del derecho del sector de la música, a quien podéis preguntar, y debéis hacer todas las preguntas que se os ocurran sobre el sistema jurídico que rige en Estados Unidos y que arma la estructura de los derechos que se juegan, con los que se negocia y con los que se tratan en el mercado de la música. Y bueno, pues sin más dilación le paso la palabra. Michael, thank you very much.
Okay, good evening, everybody. Here, right? Okay, good evening. First of all, a word to the translators. If I'm going too fast, just tell me, okay? I am going to try to explain a few things about how we do music licensing in certain respects in the United States. And for those of you, I know there's some students here and I know there's some lawyers here. So I'll try to do something in between that'll work for everybody in terms of the level of interest. My subjects are these. Talk a little bit about generally how licensing is done for music. I will explain a little bit about the performing rights organizations. We have 3. If we have time, we'll talk a little bit about copyright review and revision. And even if we have any time at all, we'll talk about there are some fun law cases that have been decided recently. The presentation that I prepared is actually a little longer than we have time for, so I may skip a few things, if you could bear with me, and I think we'll do questions at the end, but please do keep your questions so we can talk about them. Makes it much more interesting than listening to me. Okay, so how's it currently done in the US? This is the most terrifying thing. This is the music licensing chart, which I will come back to, but basically, oh, I got this pointer. You have, yes, songwriter to the publisher. The publisher collects mechanical rights and all the other rights and pays the writer. Both the publisher and the writer, like here, are members of the performing rights organizations, of which we have these, which we'll talk about. There are also royalties paid to the record labels, which pay in turn to the artists, or the artists are paid directly. If I can find my way around this chart, we'll come back to it. Well, I mean, it was all very simple. This is simple. Oh, I forgot something. until the digital world came along. This is what's making all the news. We have in the United States, as you probably have here, many different kinds of services. These are some. What's interesting is particularly this. Remember, all these services pay, whoops, I think I went too far. Yeah, no. All these services pay rights to music holders, but in fact, the major record labels own shares in Spotify and in some of the other organizations, which changes, it's a shift that results in a re-engineering of how licensing is done. And there has been all kinds of activity, which you may or may not have heard about here. That major American artist, Taylor Swift, just before she released her album, pulled all of her rights off of Spotify. Spotify said, well, I guess she doesn't need the $6 million we were going to pay to her over the course of the license. Then you have Pink Floyd that says that internet radio is a ripoff. I'm not sure how you translate ripoff, but I'm sure you'll find a way. And then you have YouTube. Can they fix their relationships with the industry? And then you have a new performing rights organization that threatens to take 20,000 songs off of YouTube, pretty much all at the same time. So it's chaotic, and what's interesting is it's big news. Financial Times, right? New York Times, Figaro, Billboard changing the way in which it does charts to include streaming. This is all within the last few months. So it's pretty serious news and serious business. In the United States, these are the major users. Pandora, which I know doesn't exist here, is non-interactive radio for computer use or digital use of some sort on individual applications. Spotify, you probably know what that is better than me, and YouTube as well. Pandora is the big issue in our country, or at least one of them now. This is a very interesting chart. In 1984, I don't know how to stop it, you had mostly cassettes, and then the CDs took over, right? So the CDs took over and wiped out cassettes, and then come 2000, the CDs own almost the whole market, and then all of a sudden comes along this thing called digital, and it starts going the other way. And we get now to 2013, whoops, went away, but basically the majority of them, how do I stop this? The majority of the market, oh well, get off of that. Okay, here we go. Okay. Let's talk about some economics. The domestic income to the performing rights organizations in the United States, about $1.5 billion. How much is the digital that everybody's worried about? Less than 10% currently. You all can tell me what it's going to be in 5 years, but that's the issue. This is just a miscellaneous that there's 700 million more that comes in from nice folks like you overseas. Anyway, just to explain, in the United States, in terms of licensing, we have a fairly complicated system where there's a legislative overlay which exists in the 3 sections that's here, which I'm cover very briefly, and then there's a lot of private negotiating that goes on. But these sections 114 and 115 of our copyright are always the subject of great arguments. And just for the lawyers amongst you, are or will be, it's the United States Copyright Act is Title 17 of the U.S. Code, and these sections are there. And if you want to try to read them and you can master them, then I think that's all you really need to know. Okay. Here's some interesting more factoids. Pandora, the non-interactive digital radio, paid $315 million in 2013 to license music, basically. Oops. 290 million of that, of the 315, went to the record companies and artists, and to music publishers and songwriters, 25 million, to give you a sense of the proportion. 15 times the amount goes to, or more or less, goes to record companies and recording artists than go to songwriters and publishers. Sound Exchange, which collects, shall we say, neighboring rights for now, for the record companies and recording artists, paid out $650 million approximately last year. The PROs, ASCAP, BMI, and CSAC, from new uses totally collected $100 million in total, to give you, again, an idea of proportions. This is all a little out of focus. Is that all right? Okay. Just a note, which I believe is true here, there's no performance royalty in the United States in downloads. An important factoid to keep in mind. I want to talk about protection for sound recordings for a minute in the United States, and I should probably get my watch out. There was historically no copyright. Well, first of all, let me explain. The concept of neighboring rights doesn't really exist under US law. It's all copyright. If it's protection of a sound recording, it's still copyright. In fact, in the Copyright Office, it's a CR designation, or it's a C designation or a SR for sound recordings. So, prior to 1972, the only protection for recordings was state law. We have 50 states. What that meant was there was 50 different laws covering recordings, or no law at all, which was more likely the case. It was covered by common law in most states. 1972 rolls along, and the United States Congress enacts protection for copyrights produced after from 1972 on, primarily just to avoid counterfeiting. In 1995 and 1998, there are further changes that produce a limited right to collect performances and sound recordings, but limited is the critical word. And I'll come back to that a little bit. Performances and sound recordings are currently a big subject for litigation and dispute in Congress because artists that released records prior to 1972, think the Beatles, think the Rolling Stones, think of all the great rock and roll artists, etc., would like to collect royalties for the performances of their recordings. But let me just clarify that the only performances protected in U.S. copyright for recordings in terms of performance rights are on non-interactive radio services. The biggest one in the United States is called Sirius XM. What that means is that traditional radio, you turn on your radio dial, they do not pay performance royalties and sound recordings to either the record companies or the artists. They do pay music publishers and songwriters, but there's no sound recording performance royalty for terrestrial radio, as we call it. In terms of who collects and how rates are set, there is a Copyright Royalty Board, which is famously referred to in the States as the CRB. which theoretically establishes rates pursuant to criteria which are set in the Copyright Act, which I might talk about. And then Sound Exchange, whoops, it's this one here. Sound Exchange is an organization it's a non-profit organization. It was established by the famous CRB and the Copyright Office to collect performance income for sound recordings. Again, non-terrestrial, non-interactive digital radio. Sound Exchange. Just to give you an idea, again, we'll come back to Pandora. Pandora is this non-interactive radio in the non-interactive digital, basically radio you can listen to on your computer or your device. It's very big, as we will see. But here's a pretty shocking piece of information. This is just one quarter period for a group called Crackers and their recording called Low. Of the performing money that came in, the performer got $543. Just to give you percentages, 40%. The record company got 44%. The songwriters got 3%. And, well, obviously the publishers got the same. ASCAP and BMI got 1%. Session musicians got 4%. But you see where the bulk of the money is going, which we talked about a minute ago in terms of those big dollars going through. Yeah.
Why the songwriter and the ASCAP and BMI are separate?
Well, because the question was that we're supposed to ask at the end, but the question was, why are ASCAP, BMI, and the songwriters and the publishers separate? Because the way our system works is that the publishers collect money in addition to the money that comes from the PROs, from the performing rights organizations. They collect money by direct agreement. So they wind up collecting for themselves monies that ASCAP, BMI, and CSAC don't collect. Okay? Let me just go to this here. All right. Now that you all, go back to the mic. Now that you all understand exactly how everything works in the United States, and that's Spotify. We'll come back. I'd rather come back to that, actually. Let's talk about the performing rights organizations and the famous Pandora dispute. So just for those who are maybe a little new to this, there's 3 performing rights organizations in the United States. ASCAP, American Society of Composers, Authors, and Publishers, founded in 1914. It's where the blanket license came from in the United States. Here's what's important is this. At the time of its founding and for the next 30 to 40 years, ASCAP was, as we say in American, the only game in town if you were a broadcaster that wanted to use rights or any kind of performing right. So if you were a bar, if you were a radio station, you would go to ASCAP and ask for a license, and they controlled all of the rights. So they were in a very controlling position. So along comes the United States Department of Justice, files an antitrust action at the end of the 30s. That's an important piece of information. We'll come back to it. Then you have BMI. BMI is an interesting situation. What happened, just as an aside, for those of you who may be a little new to this, at one point, because ASCAP controlled the broadcast market, the broadcasters sort of went on strike and refused to play ASCAP repertoire. Now we're talking about the late 1930s. As a result, many radio stations around the country had no ASCAP license, could not play popular repertoire, and basically were playing public domain material. Enter Broadcast Music, Inc., formed by the broadcasters, the radio broadcasters, to try and develop competition to ASCAP. So whereas ASCAP membership was quite restricted, BMI took everybody, country music, rhythm and blues music, whatever. So they started to develop their own place in the market and were able to compete with ASCAP. But do remember that in terms of BMI, they are owned by the people that they license, which is sort of an interesting combination. And then you have CSAC, which is a privately held corporation, which was formed to represent overseas publishers for radio transcription. It was a small, privately held, extremely profitable organization. And I'm skipping through some of the text here. I guess you can find this later. Maybe the organization will make it available. Anyway, okay, so as we were saying, in the 1940s, early 1940s, the Department of Justice sues ASCAP as a violation of their position as a monopolistic position, market dominance, violation of the Antitrust Act. And as a result of this litigation, ASCAP and the government entered into a settlement, which we call a consent decree. And it basically set up the bases on which ASCAP can operate: fair licensing, non-exclusive rights, protecting fair payment out to its members, et cetera, et cetera. BMI signed a similar decree in 1941. And what's kind of interesting, at least for what we'll get to in a minute, is the last changes in these amendments were 1994 and 2001. They are rarely changed. Okay. Let's go back, before we get into the current disputes, to how rates are determined. This section, 801B, sets out the criteria on which the Copyright Royalty Board is supposed to establish rates. And it's a fair usual mix that you'll find everywhere in the world. Protect the consumer, protect the songwriter, protect the rights holder, protect the business. Fairly impossible to do all that and make everybody happy. So this is true in the common market, this is true everywhere. So we also have these two sections, Section 114, which is the section that governs the performing right for sound recordings. Remember, non-interactive services. Ooh, there it is, non-interactive services. Terrestrial radio, do not pay, okay, for recordings. The mechanical license, the license for the music that's used in sound recordings, is covered by Section 115. There is a compulsory license rate, which gets increased from time to time. What's interesting is the Copyright Act there was a new Copyright Act in 1909. 1909, it set a compulsory mechanical license, compulsory license of 2 cents, 2 American cents. It didn't get increased until the Copyright Act was reformed in 1978 when it went into effect. So all that time went by at 2 cents a record. It's been increased regularly since then. Okay. Traditionally, the Copyright Royalty Board, this famous CRB, determines rates under 801. There's 3 judges, et cetera, et cetera. However, in the event of a dispute between the user and the performing rights organization, it goes into the Federal District Court in New York City, a regular federal court under a regular federal judge, usually the same judge for a long period of time. This court was established, this procedure was established by the consent decree that we talked about a few slides ago in settlement with the Justice Department. And so the rate court exists, disputes go to the federal court in New York City, to the rate court judge, one judge who tends to sit for a long period of time. Enter Pandora. Pandora is this non-interactive streaming service in the United States, which is quite popular. But I'll let the translators catch up with me. So, okay. Just to give you an idea, Pandora has in the United States 200 million active users as of last year. That's 200 million. Spotify has 40 million. Give you a sense of the importance of Pandora and why everybody is so upset. So ASCAP enters into a license with Pandora in 2005 for 5 years. 2005 is kind of the beginning of the era of all this digital activity. This is the rate, 1.85% of gross revenues after some deductions. It's notable because the rate that radio pays to ASCAP at the time is 1.7%, lower. Why is Pandora more? Because that's the rate they were able to negotiate. There's a lot of reasons why, but you can pick your reason. In 2010, Pandora extends to a second 5-year blanket license with ASCAP. Same rate. Now just remember, 2010, 5-year license, which means that license is coming up next year. Okay? Guess what? The publishers, ASCAP, and the songwriters hate this rate of 1.85. It's something around 1/3 to 1/4 of the rates that are paid elsewhere in the world for similar services. So the publishers say, well, we'll just withdraw our digital rights from ASCAP and BMI and make direct deals with Pandora. So ASCAP changes its policies to allow its members to do that and to make direct licenses with new media services. The reason that the dates are significant is this is all happening last year, a little bit the year before, and what the publishers are doing, the major publishers, is they are negotiating directly with Pandora and the others for a rate that would go into effect at the time that that 2010 5-year license expires. So again, next year, big year. It's worthwhile noting that Spotify and iTunes radio rates are higher because it's just more services that are offered. And we talked about this number, 200 million users from Pandora. You have to keep in mind that in the United States, The performing rights organizations have no mandate on the rights. There is no legislative mandate on the rights that they control. So theoretically, that is the reason that the publishers wanted to pull those rights out and license directly. The rumor was that the publishers were able to negotiate rates in the range of 5%, as opposed to the 1.85% that ASCAP got from the rate court. Okay, so all the major publishers pulled their rights. So what happens? What happens? Pandora fires back. It's not going to take this laying down because it certainly doesn't want to pay more than the nice 1.85% that it's paying. So what does it do? We're back in rate court again. We're back in the federal court with the federal judge, and Pandora maintains that the withdrawal of digital rights only by the publishers is a violation of the consent decree. And the court finds in favor of Pandora. At the same time, ASCAP tries to get its rates increased. And there's basically 2 or 3 lawsuits going at the same time, but they're all happening in the same court. They want to get an increase to 2.5% in 2013, 3% in 2014 and 15. Pandora, of course, is trying to get its rate reduced to the royalty that radio stations paid. So last March, now this is this year, remember, so this is sort of hot news. That's why it's in all the newspapers. Hot news, current news. Anyway, so the judge rules that Pandora has to stick with 1.85%. It won't get the same rate as radio stations, even though she admits it is a radio station. But the publishers cannot withdraw just their digital rights from ASCAP. They either have to withdraw all their rights from ASCAP or leave all their rights for performing rights in ASCAP. As she said in her decision, all in or all out. And that's based on the language of the most recent revision to the consent decree. So the publishers are faced with a choice of what to do. If they pull all of their performing rights out of ASCAP, BMI, and CSAC, they have to be able to administer those rights. They have to be able to collect those royalties in the very complicated ways that royalties are administered from the radio stations and television, and how they're divided amongst the songwriters and the publishers. And they don't really have the databases or the information to do that, which would cost a lot of money to establish. Excuse me. Also, they can't do anything that much to change anything until 2015 because of the extent of the existing licenses. By the way, that also goes for the existing radio licenses negotiated with the radio organizations and the television licenses negotiated with the television organizations. So, okay. So what is the result? This is just a by the way. The judge said that you really have to keep a single rate because it's fairer to everybody, but it should be that low rate. So what is the reaction to these decisions? Pandora says, we appreciate the important role the court serves in determining fair market value of an ASCAP license. In other words, they're delighted. What does the publisher say? The rate is a slap in the face to anyone who creates music or represents creators. So there you go. Okay. So what's the result? The result is that everybody, and I mean everybody, the performing rights organizations, the publishers, the users petition the Justice Department to consider a review of the consent decree. What you might keep in mind is that the consent decree originally entered into in the 1940s has been reviewed, but the last review took 15 years. So, however, there is a lot of pressure for this to happen this year or at the very beginning of, well, it's already too late for this year, or the early in the first 2 quarters of next year, because these licenses are all coming up. To give you an idea of the nature of this proceeding to amend the consent decree, the Justice Department in the United States asked for comment by interested parties. They got over 100 submissions. This is double pages, by the way. This is ASCAP's submission. ASCAP, this one is Sony ATV. It's even bigger. They're all citing facts and figures and what's best for everybody. Here's the National Music Publishers Association. They're all at least 100 pages, each one. Okay, so here's what people want. They want, the performing rights organizations want to let the publishers withdraw part of their rights and license directly. This is a if this happens, it's a very big change in performing rights organizations. It means that the performing rights organizations will be left to represent independent publishers and those songwriters that choose not to go with the majors. In other words, it's shrunk its ability to negotiate, let's say, from here to there. The idea is the ability to license wider rights. Originally, when the publishers moved to move their digital rights out of ASCAP and BMI, their idea was that if they had to take all of their rights out of ASCAP and BMI, they would get ASCAP and the publishers would negotiate the rates with the users, and they would, if you will, employ ASCAP and BMI to administer the rights. Pretty simple. Okay, we can't withdraw just our digital rights, all in or all out, remember? So we'll take all of our rights out, and we'll give them sort of back to the performing rights organizations as sort of an administrating body. The judge in the rate court said, I don't think so. And she said, you can't do that, and she wouldn't permit it. So one of the things that the PROs asked for was the ability to license wider rights. They wanted arbitration of rate disputes. But this is the big one right here. How do you set the rate in the United States? It's pretty arbitrary at this moment. What they want is statutory change or a consent decree change that would permit a market rate. Willing buyer, willing seller. Those are big words in the current U.S. Lexicon of performing rights. So it would function as a free market, which, by the way, is how it works for performing rights for recordings. Completely different approach. Okay. So now that you know everything there is to know about Pandora, how much time do I have? 10 minutes? I want to talk for a minute about, by the way, I really have to say this Pandora business is a big deal, because whichever way it comes out is going to dramatically affect the way, the standing, the importance, the nature of the performing rights organizations in the United States. Dramatically. It's what we would call in English a sea change, I think. Okay, copyright revision. This is Maria Palente, who is the Registrar of Copyrights. For those of you who may be new to our system, the Copyright Office in the United States, I believe, is the only body of its kind anywhere in the industrialized world. It's part of the Library of Congress, and it is at the Copyright Office where, if you create a copyright, you can file it and have your claim to copyright acknowledged, not substantiated, simply acknowledged. You submit your claim. It's a claim of copyright, but at least you have a date and a federal organization that says you claim to have this copyright on this date in this year. It's also the Copyright Office, because it is part of the Library of Congress, is the primary source for advice to Congress on copyright matters. So the Registrar of Copyrights is a pretty influential, is an enormously influential person in the area of copyright. It's not just music, by the way, it's every kind of copyright there is. So she went before Congress and she said, listen, this really isn't working. We have to fix this. It doesn't work for anybody. It doesn't work, it doesn't give effective protections, it doesn't give clear roadmaps. It doesn't give sufficient direction, and everybody's frustrated. That's directly from her testimony. What else happened? So Congress has had many, many hearings. I mean, many. And over the last few years, we seem to always be getting, as everyone says, a half a step closer to the wall of getting this done. But the typical kind of testimony that you get is you get the copyright owners, the people that create copyrights, the songwriters saying, we can't live on what we're earning. YouTube pays micro royalties. And then you have, which is an interesting statistic, you have Google and all the others saying, oh no, we're trying to do everything we can. This is awful demanding. It's hurting our business model, et cetera, et cetera. This executive of Google cited a very interesting statistic. She noted that in 2010, copyright owners asked us to disable access to approximately 3 million items on YouTube. Last year, that rose to 230 million. I would say, if anybody's interested during the question period, it's a little disingenuous, but it's sort of right in the fact. But it has a lot to do with how YouTube does this stuff that they do. Here's the other problem. Remember our chart of how music is licensed? It drives legislators crazy, completely crazy. These are actually from hearings in Congress with legislators holding up these charts and saying, how can people do business this way? So they're not happy. One guy says here, it's a PowerPoint you don't ever want to spend that much time on, which is true. Anyway, so there are two primary pieces of legislation of interest. One is called the Songwriters Equity Act, which would take us back to this willing buyer, willing seller market rate concept of setting rates that are set legislatively and by the CRB. And the other would require royalties on sound recordings for pre-1972 recordings. Whether we're actually going to get these, I don't know. 2 minutes? Okay. So that's the summary, the Songwriters Equity. Notice how they call it the Songwriters Equity Act. I love that. For the lawyers and the budding lawyers amongst you, a couple of very fun cases, and then we'll go to questions. This is the Redigi case. It's a wonderful case. I don't know if any of you dealt with Redigi when it was in. It's still working, actually, but it's not working this way. What Redigi did was it was the ability to resell your downloaded music. We have a first sale doctrine, which exists in Spanish law. First sale doctrine says if you buy something, if you buy a book, you can do anything you want with it except copy it and sell copies, basically. Same is true in records. So what Redigi did was it paid you 30 cents for each download that you wanted to resell. And it scooped up the download into its server and then made it available for sale. And if somebody bought it, they sold it to that person or that for profit. And what they said was, this is not copying. This is not a resale. This is not a recopy of the work on your computer. What they did was they scooped it up into their computer from your computer, and they sent it to as another copy to the buyer's computer. The court said, nah, basically. And they said it nicely. The first sale defense is limited to material items like records that the copyright owner put into the stream of commerce. The fact that a file has moved from one material object, the user's computer, to another, the Redigi server, the upload, means that a reproduction has occurred. So they said, no, sorry, it's a sale, you have to pay. There is a contrary ruling, I believe, in Europe, which I'm not going to get into, which is this one, Usoft, but with Oracle. Kind of went the other way, but it's Europe. And then there's Aereo, which I like a lot because it's fun. This here thing, this gizmo here we call rabbit ears, like a little bunny. So what Aereo did was it picked up performances. You'd have this little gizmo on your house or on your apartment window. It sends the performance from here to there, a rebroadcast from here to there and from there to there in your house. And it said this is a private transaction, it's not a public performance. We don't have to pay for this. Court said, nah, it doesn't work that way. It said it was a public performance, and it was described as a cable company that transmitted copyright content. So that was good, and I have to say that the courts, generally speaking, seem to favor copyright, unless it's fair use. Fair use is a whole other thing. And here's the third case, and then we'll end. For those of you, and there's no one in this room who's old enough to remember a group called the Turtles, who were primarily these two guys, Flo and Eddie. Well, Sirius XM, the non-interactive digital radio station, said they don't have to pay for sound recordings that were made prior to 1972 because they're not protected under federal copyright statutes. However, they are protected under state statutes. The only problem is no one really knew what that meant because they weren't used for these purposes. There really is very little statutory language. California has a statute that's about this big. Anyway, they sued as part of a group in California. They said Sirius has to pay us. These recordings are copyrighted under Californian law. I know I'm going too fast, I'll slow down. These recordings are copyrighted under California law, under common law and state law, and we have a right to object to their use on Sirius Radio unless Sirius pays us. And they won in California. But remember, we have a very big country. California is but one of 50 states. So there is a similar case currently proceeding in New York in the Federal District Court. And they're trying to amend the copyright law in Washington so we can avoid all this litigation and do what seems to be right. By the way, the proposal on sound recordings to pay performances for recordings made prior to 1972 does not, which is to say to bring recordings under federal protection that were made prior to 1972 does not include the termination right, which you may be all aware of. It was proposed by the Copyright Office that the law be extended to grant protection, federal protection to recordings prior to 1972, but without the termination rights that exist otherwise under our copyright law, which you maybe have heard about. Okay, some takeaways. This is for the test you're all going to have in about 20 minutes. Okay, many legislators find the structure of music licensing way too complex. Remember the chart. The advent of the internet has increased the complexity and the challenges. We have a law that was not made for the digital age, as is true in many countries. And of course, there is substantial resistance to increasing rates for copyright holders, as there is everywhere. For the performing rights organizations, all of them, all three in our country, the issues in internet licensing seem to me will fundamentally change their function in the music industry in a way that hasn't happened in decades. In the copyright law amendment area, there's a lot of pressure to change the Copyright Act, but as those of you who read the newspapers about America might have noted over the last 2 years, our Congress seems to have trouble doing anything, including sweeping the floors. So whether or not we will ever get a new act in the current term of Congress is open to question. Finally, the federal courts, in terms of opinion making, seem to be fairly favorable to copyright, except in the area of fair use, where the fair use exception to copyright kind of started like this and has grown to like that and seems to have no end in sight. So that's the half-hour update on everything you needed to know about anything I talked about in America in a half an hour. Okay? Good. All right. Thanks. I'm sure none of you have questions, but if you do, there is a microphone. Don't be shy. This may be your last chance.
Hello, Michael.
I knew it.
Yeah. I have 2 questions regarding Pandora, but I came a little late, so maybe you already...
Yeah, we covered that already.
Oh, you
Next.
did? Okay.
No, we didn't.
With respect to how the publishers have pulled out the rights of Pandora, actually in the United States, the grant of rights to ASCAP and BMI is non-exclusive. So did they need to pull out the rights? Couldn't they just at the same time license Pandora outside the system of collective management? Or did they need to pull out the rights to do that?
No, I mean, they tried everything they could think of, and the judge basically said, all in, all out. That was her ruling, because what happened was Pandora basically brought an antitrust action to prevent the publishers from doing any of those options, and they won. Or anyway, they got the district court judge to say that it couldn't happen. So you can think, I promise you that the publishers thought of every alternative of that you could possibly think of, and none of them was accepted, None of them were accepted.
And a second one?
Yeah.
Okay. How will this affect, I mean, if those rights are pulled out, how would that affect collective management in Europe? I mean...
In Europe?
Yeah. We have, collecting societies have reciprocals with ASCAP and BMI. So if these rights are pulled out, does that mean that we would get those rights to the publishers, or how would that? I mean, because obviously publishers don't want to not be able to administer those rights in Europe. I mean, they're forced to do these all in or all out in the U.S., but not in Europe anymore. So I don't know if that would affect dramatically also how those rights are administered in Spain, and they would be also administered in Spain or in Europe directly through publishers.
Think of the pan-European licensing that's presently going on. That seems to me exactly what will happen. Remember that Pandora is an American organization. Whether the publishers in America will then reach out to license Deezer, for example, directly, it seems to me that if they're going to set up a system to do that, that's what they'll do. But I think it's years in the future, because we have to get this whole business resolved first to see what's going to happen. But I think you shouldn't be counting on your reciprocal rights too much. Sorry. Anybody else? Everybody understands everything? Great.
Michael, I have a question with regard to the decision of the judge Cote. Because, well, you know very well European law, and from an antitrust point of view, what Judge Cote has settled is just the opposite from what we in Europe must, the collective management societies must apply with regard to their members.
Right.
They are obliged to allow the members to retire some categories of rights.
Categories of rights, yes.
And so my question is, if from an antitrust point of view, the decision from Judge Cote could be seen as against the principle of the consent decree that is running ASCAP, since it is constraining the market, or it is giving ASCAP a more solid position if all the rights have to be all in or all out. What I mean is that it is less flexible than the European system, that now is going to be, it is part of the collective management directive.
The collective management directive
yes.
in Europe.
So my point of view is that this decision from the American judge is just the opposite from the perspective that we must regard here in Europe with regard the antitrust law and the rights that must be assigned to collective management societies. And if there is a review of the consent decree of the ASCAP consent decree, do you think that this decision of Judge Cote could be overruled or?
Yeah. Do you want to ask that question in Spanish, or are you going to stick with the translation?
I don't know if I'm able to repeat it in Spanish.
Okay, all right. So you have to keep in mind that what the judge thinks she's doing is applying the consent decree to those facts. She's not changing the consent in her mind. She's not changing the consent decree or anything like that. She's simply saying, oh, I read the consent decree to provide for these things that the publishers can't do. So that's why people are applying to change the consent decrees, to make it clearer in one way or the other. In terms of Europe, it's pretty clear. I've been now in 4 countries in the last week, and I've met with the societies in every country at a pretty substantial level. And it's clear that everybody is watching what happens in the United States, because everybody assumes that it will do several things. One is affect the European Commission's view about how things should operate, which is a big thing, because there's this constant review of copyright rights management. It also affects performing rights organizations, as Christina was saying. What will they collect of the American repertoire? If the major American publishers scoop out the digital license. Now, the performing rights license, as we said here, was only 10%, but that does not include all the other kinds of digital licenses that Spotify issues, et cetera, et cetera. So if the publishers get into the business, the major publishers, of doing these licenses themselves. They have now had almost 10 years' experience doing pan-European licenses for mechanical rights. They have systems set up either, well, with certain performing rights organizations and not with the others. And it just seems logical that if they scoop up these rights in America, ultimately they'll get to deposit them in Europe. They'll deal directly with the licensees in Europe. Keep in mind that they deal with them fairly regularly anyway. So I think, yeah, I think there's going to be whether it's going to be legislative in Europe or just by the effect of the market remains to be seen. Seems to me it'll be both. Does that answer your question, sort of? Well, good enough, okay. Any of the students out there, anything about American copyright, American music business that you don't understand or be curious about how it works or why your favorite artist, Taylor Swift, pulled her rights from Spotify, what that means? Oh, I'm going to ask you guys a question. Taylor Swift pulled her rights from Spotify 2 weeks before her new album came out. Anybody know why? Come on, guys. Why would Taylor Swift pull her rights from Spotify when she could have made, according to Spotify, $6 million in about 3 weeks? Okay. You don't know, huh? You don't even think you know? All right. Here's why I think.
That's the short answer, to sell more copies, I guess.
To sell more copies of her record. Good, bingo, you get, that's what she says. And that's what her record company says. So here's their statistics. She pulls her rights from Spotify so they can't be downloaded in that fashion or streamed in that fashion. So, okay, fine. Her record, her first week, her record sells over 1.2 million copies, the album, in hard and full digital downloads. That represents 20% of the album sales in the United States for that week. And I think the number 2 album that week didn't hit 100,000. Second week, she sold about, I believe, about 1.1 million copies. Same picture. So that's an issue. The other thing about that that's sort of curious is she didn't pull her rights from YouTube. I hinted before when we had that slide from Google that they were complaining about all the takedown notices. Do you all know what takedown notices are? Takedown notices, yeah, okay. So the thing is that it's very hard to take something off of YouTube because the takedown notices go by, I think they go by individual URLs, so the minute something comes off, it goes up again the next second. So it's very difficult. Maybe that's why she didn't choose to fight with YouTube. But you know, for those of you who are interested in equity for songwriters and et cetera, YouTube is probably a bigger target, at least in the United States, than Spotify, but they're much harder to kind of get in the net. Okay, if there's nothing else, anything else? No? Okay, everybody understands everything. I'm delighted. It's so good to be so clear. Thanks so much for your attention, and I hope you all have a good evening.